Nevada State Government, Judiciary. The state court system of Nevada operates separately and independently of the federal court system. This is also true of all 50 states. The state court decisions, based entirely on state law, cannot be appealed to the federal courts. Nevada is no longer one of the few states that do not have an intermediate court of appeals between its Supreme Court and trial courts. Proposed constitutional amendments to reduce the Nevada Supreme Court's increasing workload by adding an intermediate court to the state judiciary system have been defeated by the voters 4 times in 1972, 1980, 1992, and 2010. Finally, in 2014, the voters approved the creation of a state intermediate appellate court. The court began operating in January of 2015 in Las Vegas at the Regional Justice Center. Nevada Supreme Court. The Nevada Supreme Court is the court of last resort in the state judicial system. Except when a federal issue is involved, its decisions are final. Between 1864 and 1915, these elections were partisan. Since 1915, however, candidates for the Nevada Supreme Court ran in nonpartisan elections. Nevada Supreme Court required qualifications. You have to be at least 25 years old, an attorney licensed to practice law in Nevada, residing in the state for at least 2 years, and have at least 15 years of legal experience. This last requirement of having to have 15 years or more of legal experience was only recently added in 2005. Now, originally, the size of the Nevada Supreme Court was only 3 justices. Since 1999, the size has been increased to 7. The expansion of the Supreme Court allowed it to hear twice as many cases as before, because justices sit in 2 panels of 3 justices in order to hear cases. The northern panel sits in Carson City and the southern panel in Las Vegas. The panels are randomly appointed and membership rotates every 12 months. The Chief Justice does not normally sit on a panel, but may do so if one of the panel's justices recuses himself or herself from a case due to a conflict of interest. All 7 justices sit as a group, en banc, to hear only most important cases, such as those involving ballot questions, direct appeals in death penalty cases, and contested cases involving attorney suspension or disbarment. Chief Justice is a rotating position held by the most senior justice, that is, the justice in his or her last 2 years of a term. However, now that there are 7 justices, it is often the case that there will be 2 or 3 justices serving the last 2 years of their terms at the same time. In such cases, the Constitution provides for the selection of the Chief Justice by lot, typically by a coin toss. In some instances, the justices cooperated, with one of them serving as justice in the first year and the other in the second. The other would serve as a Vice Chief Justice during the year in which he or she was not Chief Justice. In 1992, the voters rejected a constitutional amendment that would have allowed the court to select its own Chief Justice. The Supreme Court exercises both original and appellate jurisdiction. The vast majority of cases the court hears are appeals. An original jurisdiction, the court can hear some cases, such as cases involving writs of mandamus, writs of certiorari, habeas corpus. The legislature is prohibited from increasing or decreasing the court's original jurisdiction through statutory law. Only a constitutional amendment can change the court's original jurisdiction. On appeal, the court is restricted to hearing questions of law only, and not questions of fact. Just like the United States Supreme Court, the Nevada Supreme Court cannot give advisory opinions or hear cases involving moot issues. From 1955 to 1990, the number of cases filed increased by an astounding 2,000%. This is obviously a function of rapidly increasing population of the state. In 1998, the last year in which the court had only 5 justices, there were 4,464 cases, 2,521 of which were carried over from the previous year. so the court used to be completely overwhelmed. More than 2,000 new cases continue to be filed to the Nevada Supreme Court every year. The voters of Nevada used to refuse to ratify an amendment that would create an intermediate court level. But now, finally, we got one, as I explained at the beginning of this lecture. Justices of the Supreme Court meet behind closed door. Their deliberations are not made public in order to discuss cases they hear. They write majority and sometimes concurrent and dissenting opinions, just like the United States Supreme Court justices do. Now that we considered the Nevada State Supreme Court, let's look at Nevada District Courts. District Courts judges, just like Nevada Supreme Court judges, are chosen in nonpartisan elections for 6-year terms. They must meet the same eligibility requirements as members of the Supreme Court, except they need only 10 years of prior experience, legal experience, I should say, not 15 years. Unlike Supreme Court justices, they do not serve staggered terms. The state constitution requires that all district court judges stand for election at the same time. There are 9 judicial districts in Nevada. This has been the case since 1973. It is the prerogative of the legislature to determine the number and boundaries of these districts and the number of judges that serve in them. The smallest district has only 2 judges. The largest, comprising only Clark County, is the state's most populous judicial district, and naturally it has the largest number of judges, 33. Regardless of the number of judges in a district, district courts are single-judge courts. That is to say, every trial is presided by just one judge. In some civil cases, and in all serious criminal cases, defined as those in which the defendant may receive a penalty of a fine of more than $500 or more than 6 months incarceration, the defendant is entitled to a jury trial. It is always within the discretion of the defendant to waive a jury trial and be tried only by the judge. This would be called a bench trial. Criminal trial juries must be unanimous to reach a verdict, while civil juries may do so with just a 3/4 decision. The district courts have both original and appellate jurisdiction. The original jurisdiction is broad and includes all cases in which the legislature has not granted jurisdiction to the courts of limited jurisdiction. The cases involve serious criminal offenses, that is to say felonies, and civil cases in which the dispute involves more than $10,000. Under Nevada state law, all civil cases that involve less than $40,000 must first be submitted to non-binding arbitration. If no agreement is reached at that arbitration, the case goes to a district court. District courts also have authority to hear appeals of other issues of orders, I should say, issued by state administrative agencies, such as the Gaming Control Commission. So, for example, if a Gaming Control Commission denies someone a gaming license, that can be appealed. Appealed to who or to what? To a Nevada district court. District courts have the authority to issue the same writs as the Supreme Court, meaning the same orders as the Supreme Court. Decisions made by the district courts are appellable to the state Supreme Court. The appellate jurisdiction of the district courts extends to their ability to hear appeals from municipal and justice courts. Appeals from the justice courts and the municipal courts that have chosen to tape trials are no longer mandatory upon district courts, and the appellants must show that they did not receive a fair trial. Municipal and justice courts. These courts have jurisdiction to hear only minor criminal and civil cases, most notably traffic violations. Judges in the justice courts are referred to as justices of the peace and are selected by the voters of the state's 55 townships in nonpartisan elections for 6-year staggered terms. The Constitution does not require them to be attorneys, and therefore some are not. By statute, the legislature has additionally mandated that all justices of peace have to have a high school diploma or its equivalent. Well, that's comforting. At least they need to have graduated from high school. The legislature also mandated that in a township with population of 100,000 or more, located in a county with population of 400,000 or more, a justice of peace must be an attorney for at least 5 years. So they made it so if you live in a county of 400,000 or more, which is only 2 counties when it comes to Nevada, Clark County and Washoe County, or a township of 100,000, we don't have anything like that except within Clark County. So essentially this means, for all practical purposes, if you are in Clark County or Washoe County, this means that Justice of Peace must be an attorney with at least 5 years experience. Well, that's great. That actually is more comforting than someone just having a high school diploma. So if you're, say, in Elko County or Nye County serving as a Justice of Peace, all you need to do is to have a high school diploma. But in these large counties, like ours, Clark County or Washoe County, you have to be an attorney with at least 5 years experience. So we've got an advantage here. Also, only attorneys may serve as Justice of Peace in a township of 250,000 people or more if the county where it is located has less than 400,000 people. Justice courts have 3 major duties: to hear cases involving minor criminal offenses, known as misdemeanors, to hear civil cases of $10,000 or less, and to hold preliminary hearings in felony cases to determine if there is probable cause to hold the defendant for a trial in a district court. The 18 incorporated cities must have a municipal court. The chief function of these courts is to hear traffic cases and cases involving violations of city ordinances. Municipal court judges are selected either by nonpartisan elections or city council appointments, as determined by the city council or city charter. Those who are elected, such as judges in Sparks and Las Vegas, serve 4-year terms of office, while those who are appointed, as those in Boulder City, serve at the pleasure of the city council. State legislature requires only that these judges be citizens of the state, a resident of the city for 1 year, and a qualified elector. The cities may add to these qualifications, such as, for example, requiring municipal court judges to be lawyers. Thanks.